Ladies and gentlemen of the jury, you have been selected and sworn as the jury in this case. It is now your duty to decide the facts from the evidence presented during the trial. You and you alone are the judges of the facts. You will hear the evidence, decide what the facts are, and then apply those facts to the law which I give you in these instructions. Your decision must be based solely on the evidence and the law. In this case, the plaintiff, runner A, has brought a civil action against the defendant, the marathon organizer. The plaintiff alleges that the defendant was negligent in the organization and management of the marathon event, which resulted in the plaintiff sustaining injuries. The plaintiff has the burden of proving their case by the preponderance of the evidence. Preponderance of the evidence means such evidence as, when weighed with that opposed to it, has more convincing force and is more probably true and accurate. If, on any issue in the case, the evidence is equally balanced, you cannot find for the party who has the burden of proving that issue. The defendant, on the other hand, denies these allegations and contends that they exercised reasonable care in the organization and management of the marathon event, and that the plaintiff's injuries were not caused by any act or omission on their part. You will first consider the claim of negligence. To establish negligence, the plaintiff must prove each of the following elements by a preponderance of the evidence: that the defendant owed a duty to the plaintiff, that the defendant breached that duty, and that the breach of duty was a proximate cause of the injury to the plaintiff. A duty is an obligation to conform to a particular standard of conduct toward another. The question of whether a duty exists is a question of law for the court to decide. I instruct you that the defendant had a duty to organize and manage the marathon event with reasonable care. A breach of duty occurs when one fails to do what a person of ordinary prudence would have done under the same or similar circumstances. Proximate cause means a cause which, in a natural and continuous sequence, produces an event, and without which the event would not have occurred. There may be more than one proximate cause of an event. If you find from the evidence that the plaintiff has proved each of the elements of negligence, your verdict should be for the plaintiff. However, if you find that the plaintiff has failed to prove any one of these elements, your verdict should be for the defendant. If you find for the plaintiff, you must then consider the issue of damages. Damages means the amount of money which will reasonably and fairly compensate the plaintiff for any injury you find was proximately caused by the defendant's negligence. You should consider the following elements: physical pain and mental anguish sustained in the past, physical pain and mental anguish that, in reasonable probability, the plaintiff will sustain in the future, loss of earning capacity sustained in the past, loss of earning capacity that, in reasonable probability, will occur in the future, medical care expenses incurred in the past, medical care expenses that, in reasonable probability, will be incurred in the future. In considering these elements, you should not engage in speculation or guesswork. You must make your assessment based on the evidence presented. Remember, you are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You are permitted to draw reasonable inferences from the evidence. However, you must not resort to speculation, guesswork, or anything else like that. In your deliberations, you may also consider whether any negligence on the part of the plaintiff contributed to the occurrence. This is known as comparative negligence. If you find that the plaintiff was also negligent, then you must decide what percentage of the total negligence was attributable to each party. In conclusion, it is your duty to carefully consider, weigh, and be guided by the evidence presented to you in reaching your verdict. Your verdict must be based on your determination of the truth and the law as I have instructed. You may retire to debate upon your verdict. I hope that you all are able to work together through this. Our society appreciates your sacrifice today for the pursuit of justice.